Best you can, please raise your right hand. Sir, do you swear or affirm that the information and testimony you're about to provide shall be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. May lower your hand. All right, Mr. Wiedmer, I think these events occurred while in jail. Is that right? No?
No, he was
Okay, I couldn't.
being arrested.
All right, thank you. All right, so back on April 20th of this year, Mr. Wiedmer, were you on probation, bond, or
No, sir.
parole? All right. So there are, on this felony information, 8 counts and a sentencing enhancement. I'm told that you're going to plead guilty to 2, then the remaining 6, and that enhancement will be dismissed. Counts 1 through 7 all allege an offense called assault, resist, obstruct a police officer, each of which is a felony punishable by up to 2 years and or up to $2,000. Now, I asked about confinement because they could also be ordered to run consecutively, which means each sentence stacked up against each other. But because that's not the situation, it wouldn't happen. Count 8 is a charge of malicious destruction of police and or fire property. That's a felony punishable by up to 4 years and or up to $5,000. Now, there's this thing called a third habitual felony enhancement. And what that does within the discretion of the court at the time of sentencing would allow the court to increase that potential sentences by twice. So, for instance, for counts 1 through 7, it would become punishable by up to 4 years instead of 2 years, up to $4,000 instead of $2,000. And for that malicious destruction of police property, it could become punishable from 4 up to 8 years, and from 5 up to $10,000. But again, you're pleading guilty to counts 1 and 2, and the other counts will be dismissed. Is that what you understood?
Yes, sir.
Now, there's also an agreement here that you're going to pay an amount of restitution of $151.24. Is that correct?
Yes, sir.
Thank you. Now, on this pretrial agreement that has been provided to me, it looks like it's got a signature there underneath the defendant that's yours. I'm going to hold it up for him. Is that your signature right there?
Yes, sir.
And did you read through page 1 before signing it?
Yes, sir.
Now, before signing this, did Mr. Champion talk to you about the facts, the evidence against you, your options, going to trial, all that stuff?
Yes.
And yeah, so he's made himself available to you, is that right?
Yes, sir.
And are you satisfied with his representation at this time?
Yes.
Thank you. Now, by entering a plea of guilty, you're not going to have a trial. Does that make sense?
Yes.
You'll be giving up certain rights that you would otherwise have in a trial. That includes the right to be tried by a jury, the right to be tried without a jury, if you chose, the court, the prosecutor consented. The right to be presumed innocent until proven guilty. The right to have the prosecutor prove beyond a reasonable doubt that you are guilty. The right to have the witnesses against you appear at trial. The right to question or cross-examine those witnesses against you. The right to have the court order any witnesses you may have for defense to appear at trial. The right to remain silent in the trial. The right to not have a silence used against you. And the right to testify if you chose to testify. Mr. Wiedmer, do you understand those rights?
Yes, I do.
And even more importantly, you understand that if you enter a plea of guilty, as we discussed, and I accept that plea, you'll be forever waiving those rights as they apply to just this case.
Yes.
You also, any appeal as to the conviction and sentence pursuant to this pretrial agreement would be by filing an application for leave to appeal and not an automatic or claim of appeal by right, which is only guaranteed when someone's convicted at a trial. Furthermore, you may be given up the right to appeal issues that would otherwise only be appealable if you're convicted at a trial. You also will be given up the right to make the claim that the plea was a result of some promise, threat, or inducement not told to me now on the record. Other than the terms of the pretrial agreement, which we discussed, have there been any other promises, threats, inducements to try to get you to plead guilty?
No.
Now, we talked about sentencing here. There are 2 felonies. Mr. Champion has probably talked to you about the sentencing guidelines and or tried to give you an idea as to what he thinks I would sentence you to. Has he made or anyone made any promises to you as to exactly what the sentence would be?
No.
Now, if he's talked to you about the sentencing guidelines, I'll highlight for you that the guidelines are not mandatory. However, the court must use them, but I don't need to follow them. I generally do, but I just need to make sure you understand that it's an estimate. All right. Do you still wish to enter the pleas of guilty?
Yes, sir.
As to counts 1 and 2, those are the ones that the council selected for me. How do you plead?
Guilty.
Before the court can accept that plea, I need to have you tell me what you did that makes you guilty of that offense. So, turning your attention to April 20th of 2026, here within the city limits of Lake City in Missaukee County. Now, this involves 2 officers. One is a state trooper and the other is the undersheriff. Tell me what happened.
I didn't, sorry.
Okay.
I resisted, by not, obeying my orders.
All right, but tell me about that. Where did it take place?
Right out on the other side, right as I was about to get booked in,
Oh, okay, like inside the courthouse building here.
inside of the, state police, car.
Okay, so what'd you do there?
I was fidgeting at my seatbelt.
Okay, trying to get loose from it.
Yeah, I was intoxicated and suicidal, and so they put me immediately into the chair.
All right, so and you resisted any of the officers that were there, is that right?
Yes, sir.
And Mr. Denham or Mr. Champion, maybe to help this make sense, does the defense stipulate that two of those were Trooper Cody Campbell and the other Under Sheriff Aaron Kearns?
I do, Your Honor.
All right. Mr. Denham, do you believe the defense provided a factual basis?
Yes, Your
Are
Honor.
you aware of any other promises, threats, or inducements?
No, Your Honor.
And do you believe that I've complied with Parole 6.302?
Yes,
Mr. Champion, you agree?
Your Honor, I agree on all three.
The court agrees and finds that defendant's plea today has been made freely, knowingly, and voluntarily. The court further finds the testimony provided by the defendant under oath on the record satisfies the required elements of proof for counts 1 and 2. Therefore, he's found guilty of those 2 counts. The remaining counts and the enhancement will be dismissed at the time of sentencing. This case will now be set for sentencing. It'll probably be in about 4 or 6 weeks. Could be earlier, but I doubt it because of the way things are processing lately. Between now and then, an agent from the Michigan Department of Corrections must prepare a pre-investigation report. One such report must be prepared anytime someone's been convicted of a felony in a Michigan state court. Now, even though you've had a couple in the past, I only know that because of the habitual enhancements, they still have to do it and make sure that it's all up to date. That requires you to complete a packet of information that will be provided to you over there at the jail, and you'll have a meeting with an interview. You'll have an interview with an agent from that office. You have the right to have Mr. Champion present at the time of that interview, and Mr. Champion, once he receives the report, will come and go over the contents of it prior to sentencing. Do you understand?
Yes, sir.
All right. Hold on. Anything else, Mr. Dunham?
No, Your Honor.
And Mr. Champion, go ahead, sir.
Your Honor, the only issue, my client has been accepted into treatment with ATS. They were just looking for an outdate or the possibility.
If you give me an outdate, I'm sorry. No, that's not what I meant. If you give me a date in which he can be placed and go to that program, and if you were able to draft a stipulation with typical language, I will grant it and send them to ATS. I believe very heavily in the rehabilitation programs and efforts of that program. I said that too many times. I said the word program 4 times. Program. Anything else?
No, Your Honor. Thank you.
All right. Technically, the court's going to revoke bond, remand him into custody. By the way, that's because I want you to stay there so he can get you into the program.
Okay.
Does that make sense?
That's fine.
Thank you very much.